Hey folks, glad you could join us on another episode of Business Redefined. As always, this is your weekly, most comprehensive look at the world of business, finance, and economics. I want to talk about matters tax and specifically the subject of ADR, Alternative Dispute Resolution. Increasingly, when KRA releases their full year numbers, you can see a portion has been attributed to resolution of matters through the ADR process, and we want to make sense of this. And we are privileged to have the Associate Director from PwC, Janet Lavuna. Karibu sana.
Asante.
Thank you for joining us.
Thank you very much for having me.
Janet, for those of us who are not familiar with it, just give us a 101. What is alternative dispute resolution and why is it alternative in the first place? Because what would be the mainstream means of solving these disputes?
So the traditional means of resolving disputes are at the courts. However, alternative dispute resolution is any other means outside of court. And it's encouraged under Article 159 of the Constitution that tribunals and courts should encourage alternative means of dispute resolution so that parties don't have to go through the long drawn-out processes of court disputes, which are time-consuming, sometimes not cost-effective. Under alternative dispute resolutions, we have mediation, whereby you have a third party who conducts a party-centric discussion, but it's up to the parties to decide on whether they can reach an agreement. We also have conciliation, where the parties on their own can discuss and see if they can resolve amicably. And then we have arbitration, where you get an independent arbiter who is trained and their decision is binding and actually is not meant to be appealable. So those are the different types of alternative dispute resolution mechanisms.
One thing that you have mentioned in your statements recurrently is parties. So who are the parties in this case when it comes to an ADR process?
So particularly today, I'll talk about the ADR process for tax purposes. So the KRA has a framework which they have entrenched in the law as alternative dispute resolution out of court regulations, whereby they allow taxpayers a period of 120 days when they're on appeal or at the court to resolve tax disputes. And so the parties involved are KRA is usually the standard party when it comes to tax, because they are the tax administrator. So when they call you to discuss a tax dispute, the taxpayer will be one of the parties plus KRA. The taxpayer can appear with their agent or their advocate, and then the KRA will likely call the team that raised the assessment, and then they will also call somebody from the independent review of objections that reviews the taxpayer's objections, so that the person who initiated the assessment from the ground is present, and then the person who rendered a decision that now is on appeal can be able to also have an input. Yeah.
Let's take a scenario here, Janet. So I'm a taxpayer. I have received an assessment from the Revenue Authority. I disagreed. I went to the tribunal. At what point do I figure out maybe I should go the ADR route, or is it for KRA to trigger the ADR process and see how it pans out?
Yeah, so either KRA or the taxpayer can apply for ADR, although what we normally see is that KRA will encourage the taxpayer and then give them the forms. So there's a prescribed form that the taxpayer then fills and applies. And then because the process is now guided by KRA, they will then analyze it for its suitability for ADR, because there are some cases that they don't approve for ADR. For example, if it's a dispute surrounding tax interpretation, they're of the view that one probably, to enhance jurisprudence, has its place in the courts or the tribunal. Yeah, so under the Tax Procedures Act, a tax dispute is likely to arise first when KRA audits and raises an assessment. Then a taxpayer has a right to object within 30 days. Then KRA makes a decision on that objection within 60 days. Thereafter, the taxpayer has a right to appeal, and they have to appeal at the tribunal because the jurisprudence we have right now is that first exhaust mechanisms that are provided in law, such as the tribunal, so the taxpayer is likely to go there. So one of the catches, though, under the ADR mechanisms for KRA is that you have to be on appeal at the tribunal or at court for you to now trigger that application. But generally, I mean, if you wanted to resolve your dispute with KRA before all those other processes, it's open, but to make sure that you protect your rights to appeal, you then have to just observe those timelines and secure your right by filing an appeal when the time comes. Yeah.
Is there a threshold for what is deemed eligible for ADR? Let's say, for instance, I've been hit with an assessment of 5 million shillings. They say small ticket size, let's go the ADR route. If it's 20 billion shillings, no, this is a substantive matter, if I could call it. Let's go through the corridors of justice. Is there such a consideration?
There isn't, yeah, because I've seen sometimes even assessments in billions. Parties have gone to ADR, and it's actually very encouraged because maybe the tax heads under dispute are many, or maybe the issues are very separate and distinct. So that's a good one for ADR, because then you can even do a partial settlement and then leave the remaining issues for tribunal and court. Then it will be easier. In fact, complex matters have been resolved in ADR and have come down from billions to a reasonable amount. And even the ones which appear to be small are still disputes, and they can clog up the court and tribunal processes. So all are encouraged. What we see a challenge with is maybe complex tax matters like transfer pricing, where sometimes it's not an exact science. And so there's a call for so much documentation, but even that one, it's encouraged because you can have the technical experts and having more time to look at it, as opposed to go to the court that may take a little bit longer to absorb complex tax matters here.
Given your experience, how does the end-to-end of an ADR process look like? If I'm starting it, for example, as a party who's a taxpayer, what should I expect through the unfolding process of ADR in resolving a tax matter?
So first, you've appealed at the tribunal, for instance. Immediately you filed your appeal, at least you've secured your right within 30 days to appeal. And then you filed the relevant appeal documents. You then advise the tribunal, which will mention the case to just as an administrative process to see whether you're ready to proceed for hearing or you want to apply for ADR. So at that moment in time, then you don't have to seek permission from the tribunal to apply. You just go ahead and apply. Then you'll advise the tribunal, I've applied for ADR. Please give me the statutory 120 days to explore. So once that's done, then KRA invites the taxpayer. Most of the time, they host the taxpayer at their offices. And so they have appointed facilitators who are well-versed and trained in mediation and facilitation. And so you'll be invited. And so the first meeting, you'll do an introduction. For it to be a good process, most of the time you need a facilitator who is, not someone who takes a hardline stance, somebody who has the soft skills to encourage parties to agree. You don't want to feel, parties are there who are overbearing and that kind of thing. So first meeting, introductions, express your issues, and just be given a hearing to air out your position. And then KRA then tells you where they have a varying view. And then from there, sometimes you break off to do what they call working party meetings, so that now the facilitator may even withdraw, and then the parties now go into looking in depth into what is it that KRA was asking for, looking for, that they didn't get, and what is it that the taxpayer may have provided that KRA maybe didn't understand and needs a deeper explanation, or if there's further documentation that can be provided at that point. Yeah.
Janet, I have to ask, if the mediator is KRA appointed, what are the chances that they will have an objective hearing in this ADR process?
Yeah. So that's a good question. A lot of taxpayers have that reservation.
I'm skeptical,
because there's an appearance of lack of neutrality or independence. And yes, we say justice should not only be done, but be seen to be done. So what happened, at some point, there was some litigation around whether tribunals should be annexed to the court. And there was an outcome. Omtata took out to determine whether tribunals should be annexed under the court. So he succeeded. And so the tribunal then moved from being housed pretty much by KRA and sponsored by Treasury to being one of the limbs for the courts. And now, ideally, even when you file at the tribunal, you file under the judiciary portal. So there's a level of independence now that taxpayers feel a bit more comfortable. So the outside of court dispute resolution regulations actually allow taxpayers to appoint a self-appointed mediator. However, KRA normally may not consent to be a party to those deliberations because it's a consensual process, voluntary, and so you find KRA pushing more towards their facilitators. But I will say that the people still are able to resolve through those mechanisms. And sometimes it's a question of maybe who is the actual facilitator, because some of them are able actually to draw out independence in the process.
Is ADR, once you venture that route, is ADR cast in stone? And what I mean by that question is this. Suppose I feel that the process is not going to yield not necessarily a desirable outcome, but an outcome that I'll feel is just on my part as the taxpayer. Is there a provision for a clawback where I can say, let's terminate this process, let's go back to either the tribunal or court or whichever other avenues we were using prior to ADR? Is there such a provision?
Yeah, so the thing is, so now that you're compelled to have filed an appeal at the tribunal, that is just put on hold to determine, as they wait to see whether parties will agree. If parties don't agree and ADR collapses, you revert back to the tribunal or court, the court process. One of the highlights of the ADR process is that it's on a without prejudice basis, meaning whatever you bring out in that process should not be used against you and should not be also brought up now if you go back to court. And actually, sometimes the court and tribunal are conscious not to listen to what deliberations went on at the tribunal. So if it collapses, again, it's a voluntary process. If you feel like it's going nowhere or it's not favorable, you can pull out. And then also the beauty of the ADR process is that it culminates in an agreement where you're able to see these are the terms and you agree both sides that these are okay. And then you sign, and then it's then binding as though it's a contract between the parties. Yeah.
So I'd imagine that agreement is basically, this is the outcome, and we're expecting within this horizon you'll be settling your tax dues in this sort of installments, or how does it look like?
Yeah, so usually, it starts by describing what the dispute was about, what were the contentious issues, and then at the end, they say, now these are the settlement terms. And so it's important to be very careful, of course, that you're signing up to terms that you will be able to comply with, because if you don't, then it's enforceable. So there's definitely any party would want to have a time limit because it can't be indefinite. But that is a challenge in itself, because sometimes a KRA, for example, when you bring the issue of refunds into it, will not want to commit because they will refund based on availability of funds, and they may not know when funds may be available, which is tricky then for the taxpayer. However, for sure, KRA would also want to know, we are closing out on this, so that there's, within this set time, you should have paid. So the taxpayer goes into it signing, knowing that, yes, within this time, I confirm that I will be able to comply.
How have you seen ADR evolve? Are you seeing Kenyans increasingly warming up to the prospect of ADR? Are you seeing them becoming increasingly shy of ADR? What's the landscape looking like?
Historically, we've always had a backlog of cases, disputes at the court. And there's also been some level of uproar about revenue being tied up in tax disputes. And so, when KRA is having a conversation with the Exchequer, sometimes they'll say, this is how much tax we would have raised, but now it's held up in disputes. So they do encourage alternative means of dispute resolution. I've also seen the court has now a court annexed mediation. And so they're trying to build capacity around mediation under court-appointed facilitators for tax. And so that's still a space that is growing. But it's also another way for taxpayers eventually, hopefully, if it develops, for taxpayers to feel that this is an independent facilitator from the court that is not KRA. Yeah.
looking at the global scene, what are some of the best practices from an ADR perspective you are observing, which you would say, if Kenya adopted this, I think it will take our ADR process a step forward?
So I think globally, this is something that is being encouraged. I know like in the US, which is a very litigious society, like I think in Kenya,
We're becoming.
We are quite litigious, but it's a good thing because we have a right and a space to be able to dispute sometimes administrative action. So in the US, I think they say maybe about only 5% of disputes, not just tax generally, but general disputes end up in court, because nowadays the settlements are encouraged so that at the end of the day you can it avoids too much publicity, too much prolonged bitterness, and at the end of the day, again, court process can be expensive.
Yeah.
And prolonged. Although probably maybe if it's arbitration, you do have to pay maybe the arbitrator, but at least you know a fixed timeline within which it will end, and then that arbitrator will give you special attention in determining your particular matter, as opposed to a judge who has so many cases to determine. So I think it's the way of it should be encouraged. It's the way of the future. The Constitution encourages it. And there's so many cases actually that can be resolved when people have calmed down and amongst themselves can reach an amicable agreement. Yeah.
What are the typical challenges that a taxpayer would face in an ADR process?
Yeah. So one of the challenges, of course, is that because it's supposed to be a win-win, sometimes a taxpayer actually feels like the entire tax liability should be done away with. And so they go into the process explaining why it should be done away with. And then for KRA, for it to be win-win, taxpayer has to pay something. So basically, the taxpayer has to go into it from the get-go with knowing what they are ready to concede to, and then put an offer on the table, but at the same time hoping that KRA will also concede. But it's encouraged because sometimes for commercial reasons, a taxpayer might decide, in principle, I don't agree on this issue, but I'm willing to pay to move things forward. So that's one of the challenges. The other challenges also is that sometimes if one of the parties reneges on the agreement, for example, if there's those set timelines that KRA is supposed to comply with, let's say for refund, and then they bring other terms and conditions that are out of the agreement, we've had situations where taxpayer has to go back and maybe deal with contempt proceedings, or go back and trigger the tribunal to summon KRA to confirm that it's the agreement, which is then it's drawn into a consent agreement that the court then adopts as though it's its own decision.
Yeah.
So the court then gives itself the powers to enforce as though it was its own decision. That was one of the key things that I would add about that agreement.
You touched on the subject of tax refunds,
Mm-hmm.
a perennial headache in this country. Every year, taxpayers will raise the concern that we have refunds which we are owed, they are not being settled.
Mm-hmm.
What's your assessment of the state of play, and how do you see ADR coming into this discussion of refunds, especially where, as you rightfully observed, even in settlement terms, KRA might not be able to honor, or the government didn't put it that way, because again, the appropriation must come from Treasury, may not be able to honor the refund obligations.
So Section 47 of the Tax Procedures Act is actually a very good piece of legislation, because it's sought to address the issue of the government not having funds to pay refunds by bringing in a clause on offsetting. Yeah. And so ideally, if KRA owes you and you owe KRA, you can net off and you don't have the burden.
You shake hands.
Exactly. But we have seen a challenge because, unfortunately, we see when a taxpayer claims a refund, they're audited. And because the provision says you're allowed to offset against present and future tax liabilities, unfortunately, KRA will look for tax liabilities that then
extinguish you.
Yeah, you end up finding a way to kick the can down the road. And so first you have to resolve this other dispute which has cropped up, or even if it's not a dispute, first of all, resolve that before you have hopes of getting your refund. But in any event, sometimes it still happens that KRA owes you so much more than that tax liability that may have arisen. And still, instead of offsetting, they will still say they are validating, and the validation process does not have a fixed timeline. Or actually, the Section 47 gives them 120 days within which to validate. And if they don't, it's deemed as though it's allowed. But even then, once it's established that these refunds are due, they're supposed to pay within 6 months. So all this is not happening. And then the law says that there's an interest that accrues against KRA of 1% per month until payment in full. And nobody goes after that, and KRA probably does not entertain that. And so it's a real problem, because then, for taxpayers, you sometimes have to go out of pocket, even take loans to pay tax, because KRA will even deem taxes due upon invoicing, even if you, as a contractor, you've not
haven't
been
paid.
paid.
Yes.
Yeah, but the issue of them resolving the refunds can go on for 2 years and beyond. But I've seen also still some cases where, refunds are processed successfully, but in batches, which is okay. But then it's something that if there are no clear administrative guidelines on resolving, as clear as there are for collection, then it appears as though they only have a narrative of collection, but they never want to have a narrative of what is owed and what is a liability on the collections. Yeah.
We saw a notice coming from the Revenue Authority around tax compliance and tax compliance certificates, to be precise.
Yeah.
Maybe you could help us understand what we have seen and why it's critical and why taxpayers should take note of it.
The tax compliance certificate is necessary for somebody who wants to tender for, opportunities with government, or in, there's any other organization that will be trading with a taxpayer could want a tax compliance certificate, or sometimes even you're applying for certain positions. Yeah. And so it's a very kind of an emotive issue when, for example, maybe a tax liability is raised and you know that it's erroneous and you want to object, and you're actually exercising your right within the law to object, and then KRA takes so long, or the tribunal court process takes so long, and ultimately you may succeed in doing away with the liability, because for genuine reasons, maybe KRA misunderstood the business or did not take into consideration certain documents. And so we've had disputes around TCC. So at some point, some KRA officers were of the view that so long as you are an active taxpayer, you're filing your returns, and they are processing all these other administrative things, you should be given a TCC. But then there's the ones who of the school of thought were tax compliance means you are compliant 100%. And until you're 100% compliant, you don't get it. So unfortunately, the notice is trying to take that position of
the latter,
that you should be 100% compliant, which is, now they say you must have e-teams. You must have filed your returns. You must have, paid all your tax liabilities. You must have all these other criterias. And so for example, if you can't pay tax liabilities that you're disputing, so how can you fail to operate your business because you're
having a dispute?
Exactly. So that kind of thing, and then filing returns is already a penalty for late filing. So why again deny the taxpayer? Because the law actually encourages you to still file even if late. You just pay a penalty and you move on, because then KRA will then know your tax status. So when you deny, and for example, the special table issue, no notice, no demand, just you're blocked, your PIN is blocked, and everybody else that you're trading with can't, you can't make any refund claims, you can't transact, you lose business. So those are drastic measures. And again, it goes counter to their role as an administrator, which is to facilitate compliance, as opposed to just crashing down on somebody who is trying their best to comply. So I think probably they should reconsider, so that if you have a tax liability, you can do a payment proposal.
Yeah.
If it's e-teams, maybe you're in the process, you need guidance. There's so many hitches around that. Sometimes filing has its own problems because iTax is, after
many
all,
times actually.
Yeah, it can fail.
Yeah.
And then there are also penalties that can crop up that are erroneous. So there's so many various scenarios that can get a taxpayer into problems, even when they legitimately are compliant or trying to be compliant. Yeah.
But now that the notice is already out, Janet, are you telling us then we have no recourse? We just accept it as it is?
So unfortunately, some of these notices end up being contrary to what the law provides, and then they also generate more disputes. So in as much as KRA may deem it to be a win, but in the end it may make people even less compliant because they have to find ways to survive outside of the system.
Unfortunately, that brings us to the close of our conversation. We have been speaking to Janet Lavuna from PwC, Associate Director, on the subject of alternative dispute resolution. We have touched on the subject of refunds and the complexities and challenges being faced on that front. And finally, the new elevated requirements around tax compliance certificates. That notice came from the Revenue Authority. If you look at the raft of measures provided, there are quite a number of them. And of course, that complicates our compliance process in the country. She mentioned special table in case you were lost there. If you look at the subject of VAT, that is where the special table comes in, where you had a claim. But of course, on the other end, they have what they call the missing trader. Quite a headache for traders out here. We shall keep on highlighting these issues as and when they emerge. Stay tuned.